And I will start us off with
Whakataka te hau ki te uru, whakataka te hau ki te taonga, kia mā kinakina ki uta, kia mā tarata ki tai. Kia he aki ana te atakura, he tio, he hoka, he hauhu, ti hei mauri uri.
Good morning, welcome to day 2 here in 15B, special purpose zones and precincts voting requests. We have Mataka Residents Association, Spirits with Mr. Hall and Mr. Williams. Welcome. You've asked for basically the warning for your presentation, so I'll hand it over to you. And
thank you. Good morning.
Okay.
Good morning, Commissioners. Yes, we're here on behalf of Kaikohe Residents Association Incorporated, and have with me today Mr. Evans, who has been very much involved in the development of the Mr. Williams, Mr. Evan Williams, who has been very much involved in the development and implementation of the market scheme. We also have Mr. Goodwin, landscape architect, who has similarly been is very much involved in the development of the landscape aspects, who will join us online, and Mr. Paul, the consultant. So we did ask for the full warning. We're not expecting to take that long. So in terms of the material you should have for you, there was evidence filed setting out a proposal for a precinct in May. So there should be evidence from Mr. Williams, Mr. Goodwin and Mr. Hall. We also filed summary statements from Mr. Hall and Mr. Williams last week. So check if you've seen those.
I'm just passing those out now.
Okay, thanks.
while that's been distributed, what I will say is you've got a morning, but they have a morning tea break at some point. So we'll agree at a point or we can offer, and you're more than welcome to join us. Everybody here who participates in that morning. It's not just morning tea, it's not just us. So we'll have a break in the middle sometime.
Very sensible.
Have a nice cup of tea and just get in there.
And there's also a synopsis of submissions that I filed. I'll just check that you've seen those as well.
It's coming out now.
Okay.
Thank you. It's sort of seeing these professional matters for the first time, so feel free to read them out and if you wish.
What I will say is that there are no very additional matters. These are summaries of evidence in chief. The only other matter that I hadn't mentioned was a rebuttal statement of Mr. Hall, but that was filed some weeks ago as well. So I think you should have seen that. I'll start by a brief overview statement that I will take you through, but then my submissions are in the form of a synopsis, which I will largely talk to today. Market Station is a 1,075 hectare coastal conservation estate located in the Bay of Islands, so rural production zone under the PDT, and is subject to coastal and conservation overlays, namely the coastal environment, high natural character overlay, and the outstanding natural landscapes overlay over parts of the property. Market Station has successfully coordinated pastoral land use for farming with a very low density coastal residential lifestyle component, along with an extensive ecological and Indigenous biodiversity conservation enhancement program. The limited rural residential land uses have been sensitively designed to be sympathetic of the natural environment, with an emphasis on integration with the environmental conservation and restoration efforts at Martika Station. Martika considers that the reporting plan's recommendation in the Hearing 15B Section 42A report to include the Martika Station precinct as sought by Martika via its submission and evidence is a significant improvement on the notified version of the PDP and will positively contribute to the overall workability of the PDP in relation to Martika Station. There are some relatively minor outstanding areas of disagreement on the precinct provisions, and Martika's, that's between Mr. Hall and the reporting plan. And Martika's position is that the amendments are required to the precinct provisions in order to establish an appropriate planning framework and to ensure that the special attributes, values, and desired ecological and conservation outcomes of the local environment area of the district are properly recognised and provided for. The further amendments sought and the reasons for them are addressed in detail in the rebuttal evidence of Mr. Overall, Martika's position is that based on the evidence before the panel, the precinct provisions sought by Martika, as set out in the rebuttal evidence, will better give effect to the sustainable management purpose in Part 2 of the RMA, a statutory test for district plan making under the RMA, the applicable national policy guidance in the New Zealand Coastal Policy Statement and the National Policy Statement on Indigenous Biodiversity, the Northern Regional Policy Statement, and the 80-year vision for the district's environment as articulated in Part 1. I'll speak briefly now to the legal and policy framework. I've not repeated that. I've addressed that quite extensively in the submissions that I made on behalf of Martika and other submitters in both hearing 1 and hearing 4. And there's no real disagreement in terms of the framework that applies between Martika and everything set out by the reporting officers. We're also well through this process, and I'm sure that the panel is very comfortable with its district plan making framework. And so simply then, the main district planning requirements are in Part 2, Section 32, Section 74, and Section 35 of the RMA. In terms of giving effect to key national direction instruments and regional policy, most at the moment relevant national planning guidance is in the New Zealand Coastal Policy Statement, particularly in relation to the conservation overlays. That is something that Mr. Goodwin's evidence addresses. And a reference of where to particularly look for that discussion, you'll find that in paragraphs 45 to 49 of Mr. Goodwin's evidence in chief. Mr. Goodwin has been involved in Martika Station since 2004. There have been 3 comprehensive landscape assessments, all of which have an overarching focus and protection on enhancing the landscape and national character. And my submission that the scheme that give effect to the national, to the New Zealand Coastal Policy Statement very well. In relation to the National Policy Statement on Indigenous Biodiversity, that was a matter that I made submissions on in hearing 4 on the overlays. In summary, what I said there was that this is a policy statement that's in effect, and although plan changes to give effect to that have been promulgated by the council, then what the panel needs to do there is to give effect to that to the extent that it can through this process. Mr. Williams' evidence will discuss the extensive conservation efforts that have been undertaken, particularly in relation to kiwi and planting. And in my submission, what has been occurring at Martika Station and what is sought to continue to be achieved through the precinct provisions in the PDP are something that will give effect to the New Zealand, to the National Policy Statement on Indigenous Biodiversity. In relation to the Regional Policy Statement, this is well canvassed in the evidence of chief of Mr. Hall. Similarly, the district plan making requirements with respect to Section 32 and Section 32 KA evaluations are also addressed, primarily in attachment 2 to the evidence of chief. And finally, a comment in terms of the alignment with Bible 2100. I made some submissions on what was involved in that in hearing 1, and just to remind the panel that the pillars of that strategy document are growth and economic prosperity, stewardship and communities of care. And in my submission, the ethos of what is sought to be achieved at Martika Station and approved in the PDP very much aligns with that strategy document and vision with partnering. So turning to Martika's submission, Martika has made submissions on a number of aspects of the PDP and it has appeared before the panel on those, but of particular relevance to this hearing is the submission point that sought a special purpose zone or precinct. I just point out that there are other submitters, around 30 of the individual residents of Martika Station that have made a similar submission. And so while we appear today on behalf of the association, there is certainly support for this approach from those individual members as well. So the submission that Martika made referred to a special precinct, a special purpose zone or a precinct. And as you'll be aware, when the PDP was notified, the approach to special purpose zone was rather than precinct. There's been a lot of discussion of that along the way, particularly referred to the interim guidance issued by the panel, 15C, the horticulture zone, where we see there's a clear direction heading towards precincts.
Yeah, that sort of opened the door to precincts being a thing.
Yes.
And a number of submitters have already embraced the precinct.
Yeah.
Special purpose.
And so that is the approach that we are promulgating through our evidence. We leave the special purpose zone point in the submission live in case decisions were to head in an unexpected direction, but we're not going to address that in detail today. And there is alignment there, which if there are any questions, it's well addressed in all the evidence and alignment between the reporting officer, Mr. White, about the reasons for that direction and how that would align to the guidance in the national planning standards. So in terms of Martika's approach to the design of the precinct, the commission point has been Martika has opted in and then has put forward a proposed precinct. And Mr. Hall is the architect of the precinct and the precinct provisions, and he can best answer questions about the design and approach and the philosophy and what is sought to be achieved. But essentially the precinct uses and works with the underlying rural production zone overlay provisions as a starting point, and then an exceptions approach has been taken. So Mr. Hall has identified specific provisions that Martika says require a more nuanced approach to recognise the unique attributes of the environment and the Martika Station scheme, and the need for certainty in terms of the specific development and conservation outcomes consented and planned for over a long time frame. Briefly make some comments on the unique attributes of Martika Station. I understand that the commissioners have a site visit scheduled for tomorrow, and the practical matter is that will show you the unique attributes and the specialness of Martika Station far more effectively than I can in words. But to guide that, I think it's really useful in mind to try just keep it in mind when you're doing your site visit, the things that make it quite different and quite spectacular. And one is this ruggedness of the natural environment, the topography, the steepness, the outlooks, the overviews. It's the integration of the pastoral land uses with the conservation areas and the extensiveness of those conservation areas and planting. Mr. Williams will talk about in his evidence, discuss the vision and development philosophy that has been applied there and how that can be contrasted to the conventional approach of coastal development, which, to put it colloquially, was essentially at that point in time to try and fit as much in as you possibly could, and to see that conservation as not being something that was compatible with development. And when you go to Martika Station, it's evident that a very different approach has been taken to sympathetic design. The success of Martika's scheme, and the outcomes achieved have largely been achieved through property tools, consenting, and the incorporated society rules. those have created a real expectation of what development is supposed to look like, and almost a self-policing situation. It's very effective, it's very successful. And that's very important, because maintaining that exclusiveness, that limited development capacity, that high quality of development is absolutely essential in order to keep the values of the property high, and also to obtain the funding that is necessary for those conservation outcomes. Mr. Williams' evidence talks about the significant costs that are involved. And I think in his evidence in chief, he sums it up very aptly when he says, conservation does not just happen, it needs to be paid for, fought for, and defended. And that's Martika Station is an example of this happening in practice. So in my submission, Martika has a proven track record. You can see for yourself when you visit the success of the partially established Martika Station. And as I say, that success depends on maintaining that quality. And Mr. Goodwin, your questions for him, he can talk about the design guidelines that underpin that approach. And in my submission, it's appropriate that this background, this context, this track record is taken into account when the panel is balancing the request for more permissive PDP controls. Particular examples of that are things like around driveways and earthworks. We can talk of Mr. Goodwin's evidence, but there are examples of how that is done sympathetically and very effectively using the existing tools and expectations that have been implemented in Martika Station. In terms of the planning for Martika Station, over a long period of time, Martika has valued having a collaborative relationship with the council from a consenting in terms of the work that has gone through establishing and consenting the Martika Station scheme. Martika sees the PDP submission and hearing process as an opportunity for alignment of the vision and existing consenting structure for Martika Station with the PDPs. Martika has welcomed the opportunity to work with the council with a view to the PDP better supporting what had been achieved through those consenting and contractual tools, to continue to support the success of Martika Station in the future. So essentially what I'm saying is a long way to come in terms of developing this provision and this vision for Martika Station through using other tools rather than the RMA and strategic planning and the PDP. What we're asking for now is to align that in a way that can give the owners and Martika confidence that they can continue to implement what they have successfully partially done. And it takes a long time to develop something like Martika Station, longer than the life of PDP, but we want to try and get that alignment so that things work together. There's clear expectations of the PDP support. Commenting now on the section 42A report, and I really do see that there's a large degree of consensus, particularly between Mr. Hall and the reporting officer here. There's been some very productive discussion before focusing between the reporting planner and Martika's planner, and there is a high degree of consensus on the appropriateness of the precinct as the appropriate bespoke spatial layout under the national planning standards, and also the desirability of a precinct for Martika Station. And there's also quite a high degree of agreement in terms of the appropriate precinct provisions, which is referred there to paragraph 94 of section 42A agreement, where the reporting planner says that the amendments that he's proposing, there's no change in the intent there, it's more about workability. So that's where we see those outstanding matters as lying. Martika is very pleased with the positive recommendation in the section 42A report to include the precinct, and considers that is a significant step towards aligning RMA planning with the Martika team. Where there are outstanding areas of disagreement between the planning, Martika sees that Mr. Hall's evidence and Mr. Goodwin's claim that evidence was heard, and for the reasons that are set out in those statements of evidence. Marika says that the amendments will improve the clarity and coherency of the TDC and better fulfill the statutory and plan making requirements and will provide the most appropriate way to achieve the purpose of the RMA for the reasons discussed above and in the evidence that has been produced on behalf of Martika. Martika asks that the panel approve the precinct on the basis set out in attachment 1 to Mr. Precinct.
Right, thank you for those submissions. Yeah, firstly, we just want to say that we're very pleased that you opted into the process. This whole process sort of had its genesis at hearing 4 when we realised a lot of the things coming up present evidence at that hearing really wanted to have a special purpose zone or something similar themselves. And then we looked at the week that we'd set aside for all rezoning requests and we thought, something here. And then so through the offices, they've come up with, I think, a very, very helpful and cooperative process. And we're really pleased to see the degree of collaboration and agreement on provisions and the instrument as precincts become a thing. And so yeah, really pleased to see this outcome. And what we're really focusing on now really is those areas of disagreement. We still need to hear, we're still more than happy to hear the evidence about the context of the site, what you consider makes it special. We heard from the landing, your next door neighbours yesterday, and they were saying we're special. And we asked them, what makes you special, especially your mates next door. And so, we're happy to hear why you're special too. Maybe more special than them, who knows? But in particular, obviously, joking aside, that obviously helps your argument that you, because of those characteristics, you need a different rule framework, particularly in some of the standards and the rules that apply. So we're really interested in hearing reasons.
So thank you. I think there's two aspects to that speaking this. There's the specialist of the physical environment, but also the specialist of the approach that's taken at Martika. And so unless you have any questions about my overview, I would hand over to Mr. Williams because he is the best person to really describe.
I just want to sort of have a little quick discussion about evidence that you presented way back at hearing number 1. And you came, both Mr. Hall and gave us evidence on strategic direction, and in particular, you were recommending that there needed to be recognition of productive activities as a strategic outcome that focused on regeneration and replanting. And obviously, the sorts of things that's going to be in your zone. So what I'd like, you don't have to answer that question now, but sometime in the presentation, if you'd like to have to think about that outcome that you said you want to represent in that strategic direction. But now bearing in mind that you now have a zone that specifically enables what it was that you were seeking, whether that belief is still relevant. It seems to me that it may be that now that this precinct is likely to be recommended in some form, where does that leave that relief? Obviously, we haven't made a finding on that hearing.
No.
Yes. And we always thought that it would be at this point we might need to look like that to where we were back then. So
we might have a discussion about that with each of them.
Could be a good idea to have
I'm conscious that at hearing 1, representing a group of 6 different submitters, and now here representing 1. So have a discussion and answer that up.
Yeah, I would say I think what you presented in that hearing applies to. So yeah, very interesting to see what you said then and how it relates to now that this precinct is live. Anything else?
Just one question, the map that we have digitally, is there a A3 hard copy?
Yes.
Yes, there is. That is the map attached to Mr. Goodwin's evidence, both evidence and Mr. Goodwin's evidence. So attachment 1, John Goodwin's evidence, as the previous plan map also attached to attachment 1 to my evidence too. So if you printed it out, but
No, we don't have
you
it,
haven't
we
received
don't
the
have
hard
it
copy?
printed, no.
I can print it
It ain't
now,
full-time.
perhaps, and bring it in.
Yeah. Just it's hard to see,
of course.
yeah. That's useful.
Just one other question, probably Mr. Williams will be able to answer this one. It appears to me that you rely on the same roading network that the landing does in order to access the sites, is that correct?
Do you mean the peninsula?
Yes.
Or the,
Yeah, so I mean, there is a public road,
yes,
it could be like the,
Emporium.
yeah, and then everything has access off Rangiora Road. It looks like it goes through the landing, but it's then it flows into your property.
We're before it on Rangiora Road. We have 22 kilometres of private farm road that is completely different and independent from the landings further down, and it has its own.
Okay, so you have your own separate access off and it's Rangiora Road?
Correct.
Yeah, great. Right, I'll hand it over to you then.
Privilege. And I've got the evidence which I will clarify mine to recognise the fact that you've read the evidence, but not the summary. I'm not terribly good at just reading, so I'm going to summarise the summary if I might as we go. My evidence comes out of the fact that together with a former associate of mine, we bought that car in 2000. And we did that in the face of that car would be sold overseas and would be developed. And from a personal point of view, one of the major reasons why with my colleague was that, as I said to somebody, it's too big and too beautiful to allow someone to screw it up. And because the plans that existed amongst the purchasing community at that time would have seen development up to 500,000-600,000, and we just thought that was the wrong thing in that peninsula as a whole, and that it would just destroy the character of that. But not only one of the most important visual assets in the Bay of Islands, because everybody looks at Metica. When you're at Waitangi, for instance, you see Metica as a huge, big loaf at the end, at the north. You just look straight at it, and everybody who sails it, and people who live on the other side, on the eastern side, see it. So I've been involved with it. I led the development for 6 years as we did it, and I've been one of the board members of the owner body corporate, who is the entity today for the last 25 years. And I'm not historically a developer, and this was the first land development like this that I ever undertook. And I suspect that may be why we ended up taking just a different approach than the conventional model in those days, which is we were all a lot younger. And the traditional way was piece of land, put as many houses as you could, as close as possible to the beach, sell that for as much money as possible, and make sure you don't spend too much on the rest of it. We took a complete different approach. In paragraph 4, the dominant characteristics of Metica are that it's rugged, which you will see tomorrow, and very beautiful, and it has extraordinary views, which you'll see. But it also means that everybody else looks at it for the same reason why we've got beautiful views, everybody else is looking at us. The second thing is it's large. It's a big, rugged piece of land that is very large, and it takes a lot of effort to look after us. Then the third thing is that it's dominated by its natural character, which we deliberately preserve. The scheme we came up with was to say, let's have 30 houses maximum forever. Let's embed that into the plan from day one. And the effect of that deliberately is that roughly 1% of the land area is houses and their gardens. And that was very, very deliberate. So underlying what we're saying about conservation, landscape outcomes, historical archaeology issues, underlying all of that is the reality. 1% is residential. And then of the 1,100 hectares, roughly 350 hectares is permanently protected by conservation covenants. And then we farm 700 hectares, which again is by the internal legal arrangements, effectively preserved as a farm. And the reason for that is that I didn't want there to be any possibility that the land would end up with a patchwork of different rural permitted uses, but a patchwork. I didn't want a patchwork. It's too big and it's too natural. The combination of those values, rugged, large, natural character, has dominated what we've done with the council and marketing Manukau. And we knew that the kinds of people who would buy at Manukau, shifting to page 2, that everybody who would buy would back that. We'd not only force it, which we did by the way we structured the body corporate, and the fact that we just didn't allow people to manage the land outside their own houses. What that meant was that the only people who bought were people who bought, who got the conservation, natural character aspects. I remember landing on the mountain with a wild, then rich entrepreneur in his helicopter, and he was dropping me off, and we were on the mountain, which you will see tomorrow. And we looked around and he said, "You were selling this, right?" I said, "Yeah." He said, "I'll take 10. And I went, "What?" He said, "I'll take 10. And I said, "You sure?" And he said, how do you run it?" I said, "Oh, we've got a body corporate. So everybody's got to work together. And we all have to protect the Kiwis. And we spend a huge amount of money on conservation." He just went, "No, I'm not doing that." Because he couldn't get the vision that we would spend a whole lot of money looking after it, and that he had to work with other people. And so in that sense, the property has self-selected its owners. There are a lot of people who come and buy solely because it's beautiful and because it's not developed. But then there are people who come and they go, "No, I want more control. I don't want to spend that money. Why would you spend that money?" And that's one of the reasons why, if I may, the precinct, in my mind, is absolutely crucial, because what it does is the council then holds hands with us to hold that in a long-term position, not just consent by consent by consent. And so that is important to keep those qualities that we're talking about. And as our council said, what we found really quickly is that conservation doesn't just happen. You have to put a lot of money into it. Over the last 5 years, we've averaged 880,000 a year on conservation and land care. Literally 880,000 a year. That's what we spend. So it's a big, large, rugged property. But to keep it like that, to stop it being invaded by pests, gorse, people, but keeping it beautiful and keeping it strong and protecting the Kiwis costs us 880,000. And it would have been a bit less over the last 25 years, but it won't be. So that's an awful lot of money that has to come from something. And our plan always was that it would come from the residential value and the investments that people would make in the property, in the knowledge that they were committing to the conservation, landscape, archaeological and other values. So, Mr. Chairman, I think that's a big part of my answer to your question. How does this precinct, this property, the structure, how does that help that long-term strategy? If I understood your question, it's not by purely farming. We actually don't earn a lot of money from the farm. In fact, that's the reason I got to buy it, was because the property outstripped its value as a farm. Because a sheep farm or a sheep and cattle farm will not justify values in the far north. There are a lot of farms around that are not worth very much, and they don't produce much income. And that the reason that Bill Zabritsky sold us to me and Bill Burney, my then partner, was that he knew that the value completely outstripped its rural use. And the only way it was going to be looked after sensibly was this kind of very, very restrained approach to development. Not the horrible vision that the developer community had. So if I've understood your question, that's where the bulk of the lock-in between our structure and the council's vision and strategy is that this structure pays for an enormously expensive land care strategy. That's how it works. Going to paragraph 8, one of the conclusions that we came to quite quickly was the only way to do that is by managing Mataka as a single entity. So it's not just the patchwork, anti-patchwork theory, but it's also that in order to manage a piece of land like that and a conservation plan needs a single entity. In fact, it's even a bit hard from time to time with one entity but 30 owners. That's a bit of a demanding task occasionally. Then the second thing still in paragraph 8, we knew was that the plan had to be built around the characteristics of the land, the property. That it was, and this is a discussion. Is the fact that district-wide rules don't produce a set of management outcomes that are required at the fine-grained scale for a property like this, where in order to manage humans and houses in a farming operation, farm dogs, pets, landscape outcomes, to manage all of those together successfully, you have to have a really fine-grained, integrated set of rules. And so all the rules that exist in the district scheme are actually really important to us. And from my point of view, as the original developer and as part of the core management group, the fact that we were able to enforce the design rules that we have and the height limits, all the controls that's in there in our rules, not in the consents, but in our rules, and which we've pulled over into the precinct, the fact that they can be enforced is vital to the landscape outcomes. Then the third point, and I'll speed up. The third point is that the combination of the consents and the covenants we gave and the consent notices by the council and the rules, it's that knitting of all those factors makes it work. On the conservation, paragraph 9, we drew all of that on the plans, the fiddle. We said we're going to make this reflect the character of the property, and we're not going to try and impose a sort of semi-urban character or anything like that. We banned sealed roads. No sealed roads. We needed permeability from a water point of view. We absolutely discourage hard landscape, and we don't allow it. So we really try very hard to look after the conservation side. We have planted, on my estimation, way over 1 million trees, and we've conserved 350 hectares. If we were to plant that again, it's about 5.5 million trees, and that's what we're conserving very deliberately. And we have a really, really strong predator control. One of the scientists said to me one day, "What's your predator control strategy?" And who did it? I said, "Oh, it's probably me." So it's pretty crude. And she said, "So what is your strategy?" I said, "We kill everything that kills Kiwis, everything." And as a result, we, the scientists at DOC describe us as the Kiwi capital. The reason you will have never heard about that is that we don't talk about it. And the reason we don't talk about it is because one of the biggest threats to the Kiwi is us, people. There is a big trade in very rare species, and we have so many Kiwis that you can actually walk off the road and meet Kiwis. And if our kids take, what kids is the wrong word, they're in their 30s and 40s, but they take all their friends out at night to see Kiwis, and they'll get in a big 4-wheel drive and just drive in a circuit round one of the roads or two, and in 30 minutes they will see 20 to 30 Kiwi. Even with the noise of the car, and you can, and I walk occasionally around our house at night. Well, I do a lot of it, but I will go around the corner of a building, meet a Kiwi. She looks up, mainly she, because they're the big and bolder ones. She looks up like this, and I look at her, and we sort of keep going. That's one of the reasons why we just don't talk about it. The latest census in cities is probably over 1,000. Maybe more, because they're spreading out onto the road and onto the landing. So that's a quite significant conservation outcome. The landscape outcome, paragraph 11, you will see tomorrow, and I think it's just almost self-evident. It's beautiful, it's big, and it's very obvious. The iwi issue is really important. It's utterly implanted in our DNA. Hugh Rehari, the kamantua of Ngāti Torahina, died just about a month ago, and I want to acknowledge him and his ancestors. He's been an extraordinary friend, and he's been an integral part of our care for Manukau. He taught me more than anybody else about what it is to be kaitiaki. We're not special, we're kaitiaki. And he and his iwi guided quite a lot of our development. The Rangihoa Heritage Park, which you'll also see tomorrow, which is a 50 hectare, so 20 hectare, 50 acre outdoor museum, channel with interpretations all through it. It was designed by a guy called Ken Gorby, who worked for us, but before I was the chairman. Ken was one of the architects. He was the architect also of Berlin. Of course, he's an extraordinary guy. He designed the Rangihoa Heritage Park for us. The reason that park exists was that I sat up on the road with a guy called Charlie Rehari, one of Hugh's relations, who was in his 90s, and he was a wonderful guy. And I had Hugh and Charlie and I said, what do we do about this magnificent park, which has been a historic landscape in New Zealand's history, way before Waitangi, and arguably more influential. I said, what do we do? At the time, you couldn't actually get access into there because previous owners of Manukau had the farm gate 2 kilometres down the road, and most people who were older who did want to visit it couldn't, because it was too far to walk. And I said, what do I do? And Charlie looked at me and he said, what is not seen is not remembered. So we opened public road to it. And then we gave the gift of the land into a trust that I want the trust. I want more. And we look after it, and it's becoming a really important stop in the far north tourism network. But equally importantly, it's really important to the churches in New Zealand and to iwi in New Zealand. It's getting quite heavily used. And we have access resource historical pictures in colour. So the iwi side, paragraph 15, 16. The farming side has been important, and it is a really key component of looking at. And it is absolutely rural production is the underlying zone. We pay, my wife and I and our family retain ownership of one of the properties, and we and the other owners, we pay about 35,000 a year in levies, which even on my maths is close, is a bit over $1 million. And that is the core funding. That's again answering your question. What's the link between this outcome and the council's objectives? The answer is in here. The planning framework that I deal with, and the next, in fact, most of the rest of it, is that the planning framework helps us to control the shape of the uses, the shape of the care for the property, and it also helps us to maintain the value of the property, as I say. Those lots as bare lots, they're running 4 to 5 million currently per lot without a house. That's clearly a piece of recent media that's probably headed up, and that has two consequences. One is the council gets a lot more rates from us, even though we've only got 30 houses. We've got, or in fact, we've only got 8 or 9 right now, but we've got 30 ratepayers. They're paying on more than $100 million, really. Purposes of, we also demand almost nothing on other road. And so we think that from the council's point of view, it's actually a reasonable deal. Just going towards the back end, paragraphs 22 and onwards, we've incredibly valued the relationship we've got with the council, and I'm not being light with that. Pat Himalaya, the senior planner, has been with us from day one and has been incredibly helpful. But more importantly, he's been the way that the council's been able to just guide people who buy in. They all have their own objectives, but your rules or the council's rules and the way they frame the behaviour of people who are wanting to build houses and live there. Those council rules are really, really important. My biggest single worry about Manukau right now, and or that when the this review was announced and the draft provisions were notified, I was paranoid that we were actually going to lose the common purpose that we've had for the council, with the council over the last 25 years, through largely our relationship with Pat, just because he's been rigid in protecting the council's interests, but he understood the deal we did. It's basically a trade-off between the permission to do some developing and the council, the conservation, the landscape outcome. Underneath this, that trade has been a very strong mutual effort, and that's really why we're asking for a precinct.
Okay, thank you. That was a really helpful summary, and thank you for addressing the question that I put to you, and you've given us quite a lot to think about. So thank you. You see if the other commissioners have some questions for you. So, Commissioner Watts.
Well, more of a comment than a question. I think it's really interesting because I think this is probably the leading sort of proposal of this nature. I mean, I was on that site, I think it was 20 years ago. I was to work for the regional council and being impressed at that particular time that this whole process was getting underway. And I think it's taken that long to actually eventuate and to actually get to this stage where there's something specific in the plan, in the district plan, that recognises, this sort of initiative. And obviously the landing and other developments have followed similar suit. Bit of a difference in terms of the requirements for building heights, but that might be an issue we pursue with Mr. Hall. Whereas the landings see themselves as somewhat different, and their architect was having some problem differentiating their site from your site, despite the very special attributes of their site. It's quite hard for him to differentiate. I think he was a little bit embarrassed, but anyway, be that as it may, I think it's great that you're moving in this direction, and it's great from the council's point of view that the council can give support to it, and particularly acknowledging Patrick Kalalea. I think that's great. I know it's good to see.
I think some of my questions will be answered from attending the site visit. I do, not as much a question, but again, more of a statement. I think recognising your contribution for the significant cultural and heritage values as well. I think that the subdivision in particular highlights how far you've gone to recognise and provide that. So some of the other special zones haven't gone that far, so I think that in particular, along with the conservation landscape, but the other special zones also have done that, but didn't go that step further that you talked about this morning. And those special relationships you have with our local management. And you also recognise capital land. Many decades.
Yes.
The planning DNA of the panel. I think I'll have further questions for Mr. Hall, and probably more questions. I'm not sure if the questions will be for Mr. Hall or to you, Mr. Williams, regarding the farming operation as well, to get a better understanding about how that works, because it's a large site, but it doesn't go into detail in your evidence about how that operates or works apart from, noting that there's employees on site, staff accommodation, and it's a working farm. Did you have any narrative around that farming aspect?
Yes. Yes, I do. I can give it now or when.
Yep, no, Mr. Hall says take away.
So we have 4 full-time staff, 1 manager and 3 as the senior manager of 2 staff. That's the full-time. As most farmers, large farmers, they retain around about a dozen contractors who are coming in constantly, not counting in their shearer teams. We run about 2,500 stock units. We farm what are called lumina sheep, lumina lambs. They used to be called taimana. That's a breed of sheep and lambs that are developed, were developed in the South Island. And they're what people call the wagyu of lamb. They're being selectively bred, not engineered, just bred with about a $20 million deal with the government over the last few years. And it's now coming into restaurants in New Zealand. It now is available retail. And that's a premium product, and there are immensely strict rules about how we farm, and particularly to look after the animals. So that farming operation has that staff complement. It's the biggest challenge of the operation is actually the conservation component, the fighting, gauze fighting, it's called moth plant. We've got a real, I was talking with one of the owners yesterday, right at the end of the 9 Pump, and they're building a house there, and they're a very wealthy couple who are coming in from the States to live here. One Kiwi, one American woman who are married, and we were looking at the moth plant and saying, Evan, we just got to tackle this. And we've got the new drone technology with facial recognition and so on, and we're actually spraying it. We're getting way out of helicopters to do that kind of stuff. We're using drones. The other thing that's important about the operation farm is that we've got an enormously capable ownership group, including the inventor of barcode scanning. He's a full-time, one of the few full-time owners who live there full-time. And we've got the farm totally mapped and digitally embedded into operation schemes that mean that we know the temperature 100 millimetres and 500 millimetres under the surface on north-facing slopes, so that we can monitor them on really, really hot periods of the summer, and we know how to graze them. We measure grass growth technically, and we use so we're again, we don't talk about it a lot, although we are now starting to share it in some farming seminars. because we are using again the benefit of the ownership structure to
Thank you.
Yeah, very interesting. And yeah, I'll look at the comments from the other panel members. Thank you for your commitment, and to the values that exist on this property. Sort of leading the way, subdivision, and conservation. So we'll probably move now to some of the detail. Again, Mr. Hall, we really try to understand where it is that you disagree. So, again, thank you very much for working cooperatively. Alice? So, hand it over to you now.
Yes, as if we call Mr. Goodwin.
Do you want to sit with me first?
Yeah, and then we can get into the detail of this report.
I've made the mistake of seeing people in front of me.
Yes.
Forgetting that Mr. Goodwin, my
I
apologies.
think we may be able to get through Mr. Goodwin before we take a place. I think that might
Yeah, I was going to say, maybe we'll take.
Hello, can you hear me?
Yes, we can hear you. If you could just turn your camera on.
Good. Yeah, that's okay. Here we go. Let me try this. Might be a little bit dark.
We think it's you.
That's
It certainly is your outline, so that's good enough.
That's good. You should be able to recognise my voice by now, Mr. Chairman. So hopefully you can be rest assured that it is me. Yes, I'm phoning in actually from overseas because I'm away, but I'm happy to be here on behalf of the Medico Residents Association, and I have prepared a statement of evidence, which I'm happy to summarise. But I guess I guess just by way of an introduction, you know who I am, so I don't need to elaborate on that, I don't believe. But I have been involved in Medica since 2004, assisting, working with Mr. Williams over a long period of time, those last 21 years, initially doing a landscape assessment for the stage 2 development, which was an additional 8 house sites on the southern end of the station, and that application also went to Mr. Kilalea and was approved. And then as part of that, I also reviewed the landscape assessment originally done by Mr. Dennis Scott in 2001, which was done as a in order to support the stage 1 development. And both those assessments followed somewhat similar approaches, a relatively standard landscape assessment for the time, analysing the landform, the vegetation, the landscape character, the land use, and identifying the sensitive areas of the landscape, and also how individual house sites could be sited in order to not compromise that landscape character and clearly the outstanding natural features and landscapes that were evident and were already identified in the Far North District Plan. Excuse me. And so I guess since that time, I've also assisted Mr. Williams on a number of specific projects on Medica Station, design-oriented projects primarily, and providing advice for that. And then more recently, I've been on the Medica Residents Association guideline committee. So I've been working with 2 architects, one of them Mr. Pip Cheshire and originally Mr. George Farrant, And that process is outlined in my evidence, and the guidelines that form the basis for that process are also attached to my evidence. But in summary, when a purchaser or landowner wishes to develop their site, they have to prepare, or they prepare designs prior to going to the council, which then go to the committee, and on behalf of the Residents Association, we review those and provide feedback based on the guidelines, which are really the blueprint for development on Matika Station. So 2 architects and a landscape architect being myself, so we cover those bases, and we then provide that feedback. In most cases, amendments are made to ensure that the housing development and its associated access and mitigation planting is well integrated into the site and the broader landscape. And then that application goes to the council for their normal approval through the planning provision process. So, and I've been involved, I think it would be probably in 4 or 5 of those sites over that period of time. So I guess my role in relation to the precinct has really been to support Mr. Hall in developing the provisions and to provide the landscape rigor, or test the landscape, test the provisions from a landscape perspective to ensure that there is sufficient rigor there, that the council and also the Matika Residents Association can be satisfied that the outcomes will continue to be appropriate for the landscape context and meeting the requirements of the Residents Association guidelines. And there's been a bit of to and fro from that, and more recently I've reviewed the Section 42A Council Planners Report and have inputted into Mr. Hall's rebuttal evidence and the recommended changes to the provisions there. And I'm happy to answer any specific questions on those, or now, or as you move through those where there are specific changes to some of the provisions that relate more specifically to landscape. I'm in your hands, Mr. Chairman, as to how you would like me to proceed from here. But that's a synopsis of, I guess, my involvement in Matika and my approach to evidence and the precinct provisions.
Yeah, thank you, Mr. Goodwin. I think it might be, if you're prepared to stay online for a little bit longer, we'll hear from Mr. Hall, and then we'll hear your comments on those provisions, and then you can invite, or we can invite others to come in and supplement your evidence and provide some more justification that way. I think that might be a more efficient way of doing things. Are you happy with that, Mr. Goodwin?
Yes, yes, whatever works best.
What we'll do is we'll plow on for now then. 11.
I'll just mute.
Yeah. Yeah, thank you. So perhaps now we move to you, Mr. Hall, and just feel free to bring Mr. Goodwin in where you think is helpful.
Thank you for the opportunity to present today. What I've done is I've prepared the synopsis of my submissions also, which I'll just go over the key points, just picking up.
This is just summary statement.
That's a summary statement. Picking up your point, Mr. Chair, I'm focusing on points of difference, but also I guess I suppose starting with the why a precinct for Matika, which I think is a planning starting point. So I've covered that in my summary statement there. If I can, perhaps just start, I'll summarise as I go, as Mr. Williams has discussed the basic structural components. I just wanted to point out in paragraphs 3 and 4, the instruments which exist on the title, which provide for certain environmental and cultural outcomes. And so I've summarised those in my primary evidence, but broadly speaking, they require members to be residents to be members of the association. In turn, that ties those residents into a series of rules and the design guidelines which Mr. Goodwin has outlined. In addition, there's certain protections built into those and requirements, and protections in relation to archaeological sites, in relation to inviting iwi prior to earthworks on a site. Those exist as current instruments on the title. So the basic precinct approach has been not necessarily to replicate those, because those exist already, but to supplement them when where appropriate. And I suppose the example of that is the house sites. And so the consent notices on the title require houses to be located in the location shown and subject to certain height limits. And I'll get to this later, but that is what has driven the locations shown on the precinct plan and the height limits shown on the provisions. So I drafted the precinct provisions. The other, I suppose, fundamental of that drafting is that they exist in addition to the underlying zoning and in addition to the overlays. And that's an important structural approach which I've incorporated into the drafting, and really just want to emphasise that point also. So in other words, why is that? That is because, as Mr. Williams discussed, fundamentally it's a rural production landscape and rural production zone. So the rural production zone is an appropriate zone to sit there, and many of its provisions remain. The drafting of the precinct and set out in the overview of the precinct is that where more specific provisions apply in the precinct, and they take precedence. And so they might either be more restrictive or more permissive. And I'll talk to a couple of those, but by way of example, the height limits in the precinct are more restrictive than the rural production zone. And so that sets those out. The provisions for workers' accommodations is more permissive in the sense that it's more tailored to Pataka station, that it recognises that workers work across the precinct as a whole, in the current drafting of that seasonal workers accommodation doesn't quite fit with that sort of thing. So I think the easiest way to think about that in terms of the zone is that it's, as I say, and this is what the precinct sets out, that the precinct takes precedence. That's a normal sort of approach to precinct drafting. But that has also been applied into the overlays as well, whereby the overlay objectives and policies apply. And the objectives and policies of the precinct augment those, and sit in addition to those, and the rules of the overlays apply unless otherwise stated. And so again, the precinct sets out those particular overlay rules which the precinct will take precedence over. But the sort of broad structural approach taken in the precinct, I think that's really noting it's a new tool in the PDP. It seems to be a standard approach to precincts drafting, follows that of the National Planning Standard, and would appear to be being adopted for the other precincts, such as the horticulture precinct.
Can you just remind us, I mean, I'm trying to get the district planning working, it's offline for me. Can you think about that? So can you just remind me what overlays apply? Obviously the coastal environment overlay.
Yes, that's right. So the coastal environment overlay, pretty much the coastal environment overlay applies on the coastal strip, and that's an
It's in the evidence of
exactly.
figures.
And if you're referring to that, you'll see that the outstanding natural landscape overlay pretty much entirely mimics the line of the coastal environment overlays. and then there's high natural character areas identified on isolated spots. And then of course,
Almost, but within the coastal.
but within the coastal environment.
All of it, yes.
And then the Rangahoa heritage area applies across a small part of the southern end of the precinct. The heritage area itself, the land is not part of the precinct, so the land which was best, which Mr. Williams.
One of the things we were sort of keen to understand was, particularly with the landing yesterday, was how many house sites yet to be identified in some cases. How many house sites are outside a coastal environment overlay?
Yeah, I think the particular figure I'm talking to, probably one you're looking at is the figure 4. And that's it. Figure 5 is the operative zone, so put that aside and turn back to figure 4.
I didn't gravitate to that because
So you see that the majority are either entirely in or straddle.
Yes.
Those Overnell and coastal environment overlays.
we've got a couple that just sit outside.
That as well.
Okay, so
And
coastal
that's
environment, you've got some significant landscape and some high natural character overlays applying to the site.
the outstanding landscape and high natural character in the coastal environment.
Thanks.
So that's an important point because that drives the structural approach of the precinct whereby an approach more akin to the rural production zone is taken for the balance of the land in relation to the few house sites that sit outside of that. Whereas the values overlays are recognised in the overlay portion.
So what I've taken from your evidence is that you've got sort of like this cascading level of detail where you start with the underlying zoning, and then you apply your overlays, and they have some relevance. And then you've got your covenants and consent notice. I think they need to be seen as part of the package. Is that correct?
Correct, that's right.
And then you drill right down the precinct provisions. All those layers complement each other and interact with each other. That'd be a summary of everything.
That's exactly it. And the sort of the mechanics of that, I suppose, are set out in the precinct provisions themselves, where it says which of the overlay rules and which of the rural production rules don't apply by virtue of being the written precinct rules. And as I say, those are either more restrictive or more permissive. Just on that topic, I think as Mr. Wyatt noted in this 42A, there is the need for a general statement as to the mechanics of precincts to be introduced into the district plan, and I've suggested some wording in my rebuttal evidence for consideration of the officers in the panel.
Yes. Well, it seems to me the difference with the main difference between a special purpose zone and a precinct, other than the strict criteria that the planning standards make you apply for special purpose zones, is that it has an underlying zone applying to it, which should have some relationship to the activity that's included within the precinct. That worked quite well for horticulture. And it seems to work quite well for these types of activities as well, because you've still got a rural zone element to the property.
And very much so, Mike, and the covered this in my summary also, but the starting point of the submission actually saw the special purpose zone known as the Makaka precinct, so almost covered both bases, which is quite useful. You know, on looking at that, my initial thought was a special purpose zone. On looking at it more closely for the reasons you've noted, for the majority, you'll see it when you go there, it looks like and feels like rural production with a conservation overlay, with a limited rural residential overlay on top of that also. I think the other couple of other points where we're talking about overlays, and that you'll see when you visit the property tomorrow, is that while the property is subdivided, those boundary lines don't mean anything. Obviously, they mean everything in a legal sense, but on the ground, in a land sense, they're not visible. So the farming operation operates seamlessly over the titles. So you won't know when you're going from lot 24 to 25, for example, when you're travelling over the property. The other aspect of the overlays is that they also exist over parts of the property which are extensively farmed. And this was, we discussed this at hearing 4, in a general sense, the need to provide for farming within overlays. And it most definitely lands at Mapaka, the need to continue to farm, and the fact that the rural landscape is part of the, Mr. Goodwin could talk to this also if necessary, it is part of the natural landscape values characteristics of the place. And that's evidence in the.
Okay, thank you.
That probably covers the first introduction, by the way, of the discussion. Thank you very much.
I could probably indicate to you that the panel has no problem. So we can probably take that off the board straight away. That we understand, we accept the quite strict criteria of special purpose zone, and that a precinct is an appropriate method.
So I just wanted to perhaps just go over some of the key aspects of the precinct, because they help explain why it is. And so I've summarised over paragraph 11 of my summary statement. And firstly, the fact there is a precinct plan, which was the plan in front of you, and also on the board, and that shows the house sites referred to.
So which piece of evidence shows this best for the precinct plan, Mr. Goodwin?
Well, it's attached to mine, but probably just since I've got it open, it's also figure 1 and Mr. Goodwin's the evidence in the CSV.
We've got a big,
And you've got the hard copy as well.
This is essentially precinct plan.
That is the precinct plan. So you'll see from the precinct plan that it shows logically the boundaries of the precinct in red. It shows the house site locations, which are those locations aligning with the house sites identified on the Bill Scott stage subdivision, sorry, stage 1, and the stage 2 subdivision, which is the Mr. Goodwin's input to Rock and Store in the second stage subdivision. So those in totality are identified and numbered, and they're numbered according to the number of the owners on the site, but they're also numbered in relation to height rule, which I'll get to, and that's important to identify which particular provisions apply to which particular sites. Also on the precinct plan are common facilities, curtilage areas, and so those are coloured orange, pink and yellow areas. So one's like a beach, and the 2 other areas, one for the existing boat sheds and one for potential future boat sheds at Whale Bay, which you'll see on the property. So the purpose of those is that those exist within overlays, and those are areas where a discrete particular area of land has been identified for development that's not houses. And so it's for common facilities which the residents of the market will utilise, and it's to provide a planning framework for the use and development essentially around in district plan terms recreational facilities for private use, and secondly a set of planning provisions for restricted discretionary activity development within those areas. So that's the precinct plan. As I mentioned, the turning to paragraph 11B, the overview section that describes the special characteristics of the place, and the purpose of the precinct was able to do with management of the land, farming and conservation purposes, or providing the limited residential development common facilities within identified areas. So that limited residential development drops down into the objective policies and down into the rural framework. Page 4 objectives and 6 policies are included in the precinct, and they broadly provide for direction for enhancement, protection of special values, and how to use and develop according to the market scheme. The Next, there is a controlled activity rule in relation to a single unit or minor residential unit on a house site. And the essence of that is that rule recognises the suitability of house sites as it's been confirmed already by comprehensive landscape evaluation, DJ Scott work, and then the bottom of this will work for stage 2. But so the panel will recognise that looks very similar to the outcome that was ultimately recommended for officers at hearing 4 in relation to house sites which have been identified on a subdivision scheme already. The key difference, of course, is that, and the benefit, of course, is that with a precinct, they can be particularly identified. In other words, those specific house sites can and have been identified as the places where controlled activity, controlled activity subject to area. That ultimately providing for certainty of development, which I think we've heard about. The specific provision made for new buildings and alterations, as I mentioned, within areas 1, 2, and 3, which is the coloured areas, the common facility in the areas noted. If an approach to earthworks and vegetation control have been taken, so specifically this recognises that the basis of this is that there is already an extensive network of roads on the property, and in relation to undeveloped sites, the piece that needs to be done in relation to earthworks specifically is the formation of platforms and the construction of an access road, spur road or driveway, I should say, from the main road down. And so in recognition of that relatively limited extent of earthworks required for each house, for the house site across the property as a whole, that's been provided for as a restricted discretionary activity with a range of assessment matters set out there for when that applies. Noting that that is reflected in the overlay areas, and so where house sites are in the overlay areas, restricted discretionary activity.
So are you going to pick up on the differences you've got with the planning officer later in your
very soon, yeah.
Yeah, rather
Very
than
soon. A couple more points, I'll get to that. Specific earthworks, vegetation removal activities for the construction of buildings, associated curtilage with the house sites areas 1, 2, and 3, as mentioned. H, a permitted activity rule for workers' accommodation, recognising that provision is necessary for workers living within the Matika station property, both permanently and temporarily. And that's provided on one lot in particular. And so across the one of the type is owned, lot 43 is owned by the Residents Association. And that is the lot where particular allowance has been made for workers' accommodation in relation to the precinct. Visitor accommodation. This is an example where the general rules of the plan were all but, I suppose, good enough in relation to the precinct, except that they have some particular limitations which in relation to visitor accommodation. Namely, for example, one of the rules is that in the provision for workers' accommodations, that workers' accommodation can't share a driveway with another dwelling. Of course, the very nature of Matika is that all driveways are shared by other dwellings, and so the rule has been incorporated into the precinct, but that shared driveway limitation has been removed. And lastly, maximum height, specific height standards applying to Matika, and we may very well get some questions on these, but as I say, broadly, they follow the height limits which are provided for by consent notices, and where no consent notices apply, they apply a more restrictive height limit that would otherwise apply under the rural production zone. So if I can then jump to paragraph 17, just to into that view of the differences, and there are very few, I suppose, between myself and the wife. I've covered those in summary form, paragraph 18 onwards, in my evidence. The one sets out 6 relatively minor questions which I've responded to in my evidence. Starting across over the page on page 7, paragraph A. I propose a new wording to the notice section under the rules which achieves the same outcome sought by Mr. White, in my view. This applies to separate note 2 and deletes a reference of the precinct plan being indicative, but points to the need for reference to the consent notice which apply to the relevant titles. So the 42A recommendation was that the note refers to the precinct plan as indicative. I think our outcomes sought are the same there. It's perhaps just a different way to get there, and that's just to make the point that at the scale of the precinct plan and at the notation provided, the house sites certainly don't occupy the asset, but they are in those locations. And so how to resolve that particular issue is that sitting underneath on the titles is reference to the surveyed house site locations at Mataka. And so really it's a way of saying, yes, look at the precinct plan, but you should also consult with the consent notices for more specific obligations. So those more specific obligations do cover things in addition to precincts, such as the obligation for early engagement prior to earthworks, avoidance of archaeological sites, make sure there's a 10-metre buffer from those. There's a range of other matters provided for in consent notices, and we've not sought to reinvent those, but we've cross-referenced those in the note.
It would be helpful for the panel to have the colour-coded provisions before the initial working committees. Actually, on the same page, if we.
Yeah, I've got
We've got that, and
I've got your rebuttal evidence, so that's the latest version.
That's the version.
So we're looking at those provisions right now, and those are the ones where we responded to the 42A report. And then and after the break, I'm going to invite Mr. White to make some comments. How to drive with one life, sort of encouraging the conversation here.
Secondly, in B, there I generally agree with additional wording to the matter of control, matter of discretion, as has been recommended in the officer's report. As I set out, the wording should be more specific and apply to outstanding natural landscapes rather than natural landscapes. And so there was the recommendation that in determining matters of assessing matters of control, that any mitigation matters, regard should be given to natural landscapes. And I think the point being is that the plan identifies outstanding natural landscapes. So that was just more of a, in my view, just precision of wording needed in that case. C, Mr. White addresses the need for more specific rule for earthworks and indigenous vegetation and clearance associated construction of the building. We're in agreement on that in relation to the house sites. He's adopted my drafting. There's a point of difference in relation to the balance of the Mataka station, which I'll get to very shortly. Brings us to that point now, actually, which is the point of difference in relation to indigenous vegetation clearance and earthworks. So on page 8 in Roman 2, there I've covered that. So I sought and support the exclusion of Mataka for vegetation clearance and maintenance and restatement, the removal of regenerating Mataka or Tānuka tree ferns or scattered rushes applying to vegetation less than 10 years old. And this is opposed to the 5-10-year-old cut-off recommended in the equivalent rule in the 40 report. Note here that the exclusion generally followed and provided for in Rule IBR1 of the Ecosystems and biodiversity chapter of PDP, which provides for the removal of clearance vegetation. Business vegetation being cleared less than 10 years old. This I think is consistent with the evidence I presented in hearing 4, where effectively in relation to outstanding natural landscapes, I noted that there is the need for the maintenance of pasture. In some instances, the pastoral aspect defines the outstanding natural landscape. And I found it not unreasonable for an allowance of such pasture where it's less than 10 years old to be cleared of indigenous, specifically Manuka tree ferns, scattered rushes, in other words, that indigenous vegetation which is tolerant to grazing. And again, there is, I take from the 42A report on hearing 4, there is agreement on that with the officers in broad terms, in principle terms at least anyway. And the only point of disagreement here is whether that vegetation should be up to 10 years old, in my case, or no older than 5 years. So that's probably the point of disagreement in a nutshell. Lastly, I do not agree with the recommended addition of the word protect in precinct objective 4, as recommended by Mr. Wyeth. And so precinct objective 4 as drafted, and I'll just check, states that new residential units, minor residential units and buildings or structures for recreation activities are designed to be integrated with the characteristics, qualities and values of the O&L, natural character of the coastal environment. And the officers in relation to this hearing have recommended that be designed to be integrated with and protect the characteristics. And I've opposed the addition of the word protect in mind, and the reasons being, as I noted at the outset, the obligations to protect the values of the characteristics, qualities and values of the O&L and natural character of the coastal environment, they apply because they are a feature of the objectives policies of the those relevant overlays. And so this particular new obligation to be integrated with those values sits in addition to those. So again, it's a fundamental structural point, I suppose, that the objectives and policies of the overlays apply these precinct objectives and policies augment, and so I didn't see a need to repeat the obligation to protect within the precinct itself. It's providing more specific direction to be integrated with. Probably then lastly, two slightly sort of mechanical issues. Mr. Wyeth in his recommendations had recommended removing from the overview section the section which explains that the precinct provisions apply in addition to or an exception to the overlay provisions. And in my view, that usefully is retained within the precinct, simply because it's the same form of explanation is provided for in relation to the zone rules, and I think it's sensible to also state that mechanical basis within the precinct itself. And then to round out for that, I've just noted the need, as I said earlier, for an overall statement within a PDP to explain the workings of a precinct. I've still got some word in there for in my rebuttal, but in effect, it says that the precincts apply, and where a more specific provision is provided within the precinct, and that overrides the zone or overlay in your statement.
Thank you. I had the signal that I'd like to have a break now. And I can, so what we'll do is we'll take a 15-minute Are we all ready to go?
Yes.
So the sliding door will open. And you're just all welcome to Cascade and have a cup of tea now, and they'll come in and ask us again.
Thank you.
Mr. Goodwin, are you happy to hang around while we have morning tea?
Yes, I can do.
No, thank
I
you.
can do.
Thanks. Well, we'll be adjourned.
Okay, I'm just going to stop the recording.